I can hear you great. Thank you.
Oh, yes, I can see you. Look at that. Wow, our IT people are wizards. Anyway, we only have two cases left for the sitting, and the first one is 23-20351 U.S. versus Mcneal. Ms. Meyers. Ooh, what a delight to have you arguing.
Marjorie Meyers, Federal Public Defender, representing the defendant appellant, Mr. Mcneal. So the issue in this case is whether the district court refused to calculate the guidelines as necessary before deciding to impose a non-guideline sentence. The first issue is whether the court has to calculate the guidelines. The government suggests that under Federal Rule of Criminal Procedure 3B, that the court can say, I don't need to calculate the guidelines because it won't affect my decision. I think that's a misreading of that rule. That rule really refers to factual disputes. It would read the guidelines right out of existence. Clearly, the court must calculate the guidelines. The Supreme Court has said that, and this court has said that. And the cases cited by the government don't stand for a different proposition.
Just stepping back a little on background, your client got 60 months.
It did.
So that's outside the guideline range, and that's often the word that's used, outside.
Yes.
But there seem to be two issues here. You're alleging broadly procedural error, reversible procedural error. Is that because it's your view he had to reach the enhancement issue as to whether the gun he was charged with was connected to the assault and the murder?
Yes, Your Honor.
But wouldn't the district court have actually been doing Mcneal a favor by not sort of prejudging that issue that was pending in state court? In other words, it is a factual dispute. The probation office, if I remember, thought it didn't need to connect to the gun, but the government sort of responsibly said, we're not sure we can connect it. So I guess I'll turn that to a question. So if instead a district court says, I've looked at the range, I've considered the range, but this is where I'm going to get to, why isn't that a valid pre-terminating of a disputed factual point?
Because, well, first of all, I don't think the court would have been doing Mr. Mcneal a favor, because whatever the court did in the federal case, even if the court said, I think there's a preponderance of the evidence that he's responsible for the murder and the aggravated assault, that wouldn't determine anything in state court, if only because of the different standard of review and rules of evidence.
Right, but boy, you wouldn't want a disputed sentencing hearing. I guess I shouldn't go. I mean, it's your choice, but I guess
there doesn't have to be an evidentiary hearing. There has to be a determination. And what's very strange about this case is the defendant repeatedly objected on whether or not the government had adequately tied Mr. Mcneal to the other cases. The government gets up and says kind of two inconsistent things. Says, we don't have the shell casings, we'll concede, we may not be able to tie them, but we think by a preponderance of the evidence there's enough. Preponderance of the evidence is the standard. You don't need an evidentiary hearing. And for example, had the court gone through what the pre-sentence report laid out and said, I think that's sufficient, then the court would have made a sufficient determination. And I might add, in contrast to most cases, district court never adopted the pre-sentence report. The statement of reasons says the court did, but I don't think this court can rely on the statement of reasons, which is inconsistent with the fact that the district court not only did not adopt the report, but specifically and repeatedly said, I'm not figuring out what the guidelines are.
But he did say that initially, but then he seemed to catch himself and say, wait a minute. I have to start with the guidelines, and I have considered the guidelines. Everyone knew what the range alternative was. It just depended on that enhancement. And then he says at the end, and he's asked by probation, what are your reasons? And he gives a 3553 variance.
Yes and no. Everybody talked about a departure. The government asked for a departure, and the government asked for a departure. I recognize after Booker, in fact, the Sentencing Commission was trying to get rid of the distinction, but whatever it is, we really are talking about an outside the guideline sentence. I do think that the court can say, I think the defense says this is the guideline, the government says this is the guideline. Having looked at everything, I think even the higher guideline is not enough. But then the court must explain why the higher guideline isn't enough. And what's causing concern in this case is both the government and the court gave two reasons for an outside this guideline sentence. One was this conduct that the defendant had just been engaged in, and the other was the criminal history. Well, the conduct is the issue. And if the court started with the enhanced sentence, which the court seems to say 30 to 37, which is the enhanced sentence, then the court would have to explain why that 4-level increase is not sufficient to consider the conduct that it appears everyone is considering.
You all did object to the PSR enhancement.
Yes, Your Honor.
Did you object to the paragraph at the end, paragraph 90, that said, here's the factual basis for either a variance or a departure? 18 convictions, that's criminal history, justifies a departure, or he's a super dangerous guy, offense specific, that's a variance.
We objected, actually, we objected to a departure, but at sentencing we said, if you're going to depart, this is what we think it should be. And there was a discussion of the criminal history. And one of the things that is the government and the probation office kept emphasizing that he had 18 uncounted criminal convictions. Yeah. It's not the number, it's the nature of the convictions. And if one goes back and looks at the convictions, most of them are essentially shoplifting, except that the defendant goes into the store, remains there, and steals something. The only conviction that's similar to this one is the final felon in possession conviction in 2008, which did involve some violence, but that one's considered. So I would say that yes, the criminal history, we didn't dispute that the court could consider criminal history, but the issue is where do you start? And the problem is both the government and the court are using both criminal history and these two allegations surrounding this case and kind of using it twice, because they're starting at 30 to 37 and then saying, and this conduct is really bad. So I think that's the problem, that the court this court can't figure out what it is the court was doing, because the court kept saying different things and said 3 times, not an isolated remark, said over and over again, I don't have to calculate the guidelines. I'm not going to calculate them. The Fifth Circuit can't make me calculate them. And so I think that it's clear that the court did not calculate the guidelines. And so then the question is, the court did have both ranges in front of it, and whether or not, having not calculated the guidelines under a harmless error standard, the sentence can be affirmed anyway.
I guess, just to clarify then, you're making a procedural argument.
Yes.
Is it he couldn't pre-termit an issue? Is it, oh, is it my, it's
It might be because Oldham is not on mute or something.
Do you want me to mute?
Do you hear any background noise, Judge Oldham? No?
No, sounds great to me, but if I'm causing it, I can mute.
Maybe try muting. I don't think you're causing it. It's our problem here. There you go. Yeah, I guess it has gone away. So specifically, which of the 3 or all 3 or a combination? District court didn't start by calculating the range, or didn't sufficiently explain the upward variance from the range, or could not here pre-termit a disputed issue of, I'll say, fact?
The court did not calculate the range. The court repeatedly said, I don't have to calculate the range. I'm not going to calculate the range. There's even a back and forth about this is unadjudicated conduct in state court. Generally, the case law is clear that the court must calculate the range and then decide if the range is sufficient under 3553A, either to depart or vary or give a sentence outside the guidelines. I can envision a case where the court says, looking at both guidelines, in fact, I had a case a month later with a downward departure. Looking at both guidelines, neither of these guidelines accurately reflect the appropriate sentence. But then what the court would have to say is, even if it's 30 to 37, even if I overrule your objection, the higher guideline is not sufficient, so clearly the lower guideline isn't sufficient, and I would give a sentence above the guidelines regardless. The court, I think, could do that, but then the court's reasons should not include the reason for enhancement. So the problem here is the court is saying I don't have to, but the court's reasons for an above guideline sentence are twofold. One is criminal history, and the other is the nature of the conduct in this offense. Well, that is the conduct that is the subject of dispute, whether it happened and whether it was relevant conduct.
So you don't think the record is open to a conclusion that when the government said they couldn't prove up the enhancement, the court said, fine, I'm going to accept your upward departure recommendation, and then probation says, well, you have to give reasons, and the court says criminal history plus he's a dangerous offender?
I don't think the record is clear. The government talks out of both sides of its mouth and says both, says the nature of the conduct and the criminal history, and I think the court also says both.
So you would have us vacate and remand for the court just to say just that? I'm not making a preponderance finding justifying the enhancement, but I'm sticking with 60 months because really bad guy in the past, really bad guy now in the future? In other words, what would change?
I think, first of all, as a reference point, not just in this case, but for district courts, I think it needs to be clear from this court that the court needs to calculate the guidelines or make a statement on the record that I've considered this guideline, and for these reasons, they're not sufficient. The court can't. I mean, the court here says, I'm just giving a 3553A sentence. I mean, that makes the guidelines go away. So number one, I think just as a matter of policy, the court needs to make it clear that the district court needs to make a determination.
So when defense counsel said, no, wait a minute, you've got to consider them, and he says, quote, I agree, I have to take them into account, that can't be said to be he was aware of all guideline range options.
But then he says, but I'm not considering them. This isn't a guideline sentence, so I don't think it does.
Okay.
They go back, I mean, depends how you read the record, but they go back and forth, and I think he says that he's not considering the guidelines at all, which is problematic. If there's no further questions, I'll save my time for rebuttal.
Thank you. Is it Bahry? Okay.
May it please the court, Lauretta Bahry for the United States. There is no dispute that the district court considered the guideline range with the firearm enhancement and without the firearm enhancement. This is an upward variance because the court concluded that neither range was sufficient to address Mcneal's criminal history under 3553A. The enhancement played absolutely no role in the court's selection of a 60-month sentence. Therefore, the district court did not need to rule on the enhancement. Toward the end of the sentencing hearing, I direct the court to Record 163, where the court stated, it is insignificant to rule on the enhancement because it would not make a difference in my sentencing, which has to do with the 3553A factors.
That's at the very end?
That is at the very end. Throughout the...
Now, that's a variance. In your brief on page 6, you said before sentencing, the government filed a memo and it asked for a departure or a variance.
Correct.
There's no request for a variance in that memo, is there?
No, there is not. But,
so you should have corrected that.
Well, I don't think this court has ever overturned a distinction between a variance or a departure.
No, I'm suggesting from the standpoint of the government briefing, if you say to us your memo before sentencing requested a departure or a variance, and then the district court in the end gives a variance, and you then tell us you asked for both, that's just factually wrong.
I think the prosecutor did ask for an upward departure, yes, Your Honor.
Only a departure?
Yes, because I think the prosecutor was mistaken about the facts supporting whether the enhancement could be applied, but the memo also states that irrespective of the enhancement, the prosecutor will request a sentence above, and that's exactly what the the prosecutor did at the sentencing hearing.
When the prosecutor starts the sentencing hearing, he asks for a departure again.
Correct.
All the way till the end, everyone's talking about a departure.
That's correct. But let me point out, Your Honor, that even the enhancement, with the enhancement 15 to 21 months, the court understood that was the range without the enhancement. That's at record 146. Then the defense counsel even agrees that 30 to 37 with the sentencing enhancement could be used as a starting point. That's acknowledging that the court's considering both ranges. That's
No. My focus is just, obviously everything these days is guilty pleas and sentencings. And there's a gulf of difference between a variance and a departure.
I think
showing that's necessary, and the probation had it just right, distinguishing the two. But the difficulty is, when you say in your brief, we asked for both, it makes it look like this was from start to finish a variance. But you can disagree if you think I'm wrong. The government, from the start, in its request for sentencing, adopted by the district court, throughout, clarified by reasons by probation, all contemplated a departure. Is that correct?
That's correct. And the district court, consistent with what it said at oral pronouncement, decided not to do a departure, which it is permitted to do under Gall, under Step 2.
But the error then infects the statement of reasons.
No, Your Honor.
Well, listen to my question. Did the district court, yes or no, did the district court check a box that there was a motion for departure?
No, the district court.
But that is what the motion was.
That is what the motion was.
Okay, and then did the district court check that the pre-sentencing motion was for a variance? Yes.
At 232 to 233,
And that's a mistake too.
I'm not aware that this court has overturned any conviction.
I'm not saying what's overturned. The problem is your briefing. This is just not a slip up. This is, you say affirmatively that the government asked for a variance, but the government didn't.
I think, Your Honor, if you look at 163 to 164, the very last thing the prosecutor asked for at sentencing was, Your Honor, may we clarify, is this a 3553A
Well, the exact
variance?
words is, would you give the same sentence? Now, the prosecutors do that a lot. That becomes an alternative basis. Are you suggesting this record, the government was giving up its arguments for departure and saying instead it should be solely based on 3553? Is that what your argument is?
I think that is a reasonable alternative, and here's why.
Not is it a reasonable alternative, is that your argument?
That is my argument, that this is
So the government was correcting everything the district court had done in that final sentence and saying, you can't, our recommendation for departure, your adoption of the recommendation, probation's defense of it, all of that's wrong. Instead, you should be doing a variance. Is that what the government did in that final little section?
I don't think it's clear, Your Honor, because I think throughout it was the terms were used interchangeably, and I'm sure it could have been cleaned up better. Yes, Your Honor, but ultimately that enhancement played no role in the sentence, because here's why. And with respect to my colleague who discusses that the facts of the enhancement played a role in the criminal history, they absolutely did not. And here's why. The district court stated that at record 162, the court specifically pointed the parties to PSR 7 through 13, where the court focused that its sentence was based upon his continuing and episodic criminal history, and that had nothing to do with the enhancement. And the court focused on the chronicle of 39-year criminal history beginning at age 21, where he accrued 4 thefts, the last one at age 35, where he served 16 years, 5 trespasses, 4 burglaries, and at age 48, he accrued a felon in possession of a weapon.
Well, okay, but correct me. See, this is why it's so important to delineate which you're doing, because I think I'm right, but correct me if I'm wrong. It's been a while. If you're going to rely on criminal history under a representing, that's a basis for a departure. If you're going to say an individual is dangerous, that's a basis, offender characteristics for a variance. What you're describing right now sounds like you're going back to the justification for a departure.
No, Your Honor. I'm explicitly upholding what the district court said, that this was a variance that's consistent with its written statement of reasons at record 232 to 233, that this was based exclusively on his criminal history. And the latest, all of that 39-year history culminated with the offense conduct, which the court was referring to, the federal possession of a firearm. The court deemed that alarming, given that he was a 60-year-old man. Now, defense counsel states that I referred to Rule 32 for the position that the court need not calculate the guidelines. That's not what the rule states. It simply states that the resolution of the PSR dispute is unnecessary where it's immaterial to the sentence.
Okay, I agree with you on that. If it's unnecessary to resolve fact dispute, no one needs to. And am I right that the government itself was being responsible, saying we don't want to try to prove up something that's being charged in state court?
I think that the prosecutor was mistaken that the facts of that enhancement had to show that the firearm was the exact same one that was used in the federal offense. I think perhaps that's why the district court never resolved the enhancement, because there was some confusion.
So, okay, I haven't studied that. So you think probation's right, that the enhancement would have applied?
I absolutely do, but ultimately it wouldn't have made any difference because the court stated time and time again that it need not address it, record 144 to 145, because the sentence was based upon conduct and criminal history. And at record 146, the court stated, I took them into account, them being the sentencing guidelines, which is straight out of the language of Molina-Martinez. Then even using the next step, which was 30 to 37 with the enhancement, the court used the language from Gall. I'm going to use this as a starting point.
Okay.
And defense counsel.
So, okay, two questions then. So you're saying this transcript shows the court fully calculated the guideline range and had to before departing or varying either one. This judge did, and that is required.
I am saying that yes, the court needs to calculate the sentencing guideline range. Absolutely, it does under Gall, and the court did that.
Okay,
but let's, even if it didn't.
Well, no, it needs to under Gall. I agree with you on that, and then the court has to explain how it gets to 60.
Correct, and the court did that on this record. It took step 2 of Gall. It followed the procedures under step 2 of Gall, which says that the court is permitted to deviate from the guideline range based upon the 3553A factors.
So when the opposing counsel says they interpreted your brief to being a judge could just pick out a number under 3553 departure outside the guidelines altogether, that isn't the government's position.
That is not my position, Your Honor. The court considered all of the ranges, and even if it didn't consider one of the ranges, let's say the next bump up, which the federal public defender asked for, which was 37 to 46, that was at record 152. On this record, the court stated, I'm selecting a 60-month sentence, and that's independent of any guideline range. That's straight out of Johnson. And I think on this record, even if there wasn't all of the discussion about all the applicable ranges, the court was very clear that in its mind, it had a 60-month sentence in mind, explicitly based upon the 39-year criminal history, not related at all to the enhancement. With respect to the comment that the Fifth Circuit can't make me rule on the sentencing guidelines, I don't have to consider the sentencing guidelines, that's incorrect. At record 146, the court said, the Fifth Circuit can't make me rule on the enhancement. The district court never said, the district court can't make me consider the sentencing guidelines. That's inaccurate. I think for future cases, the clarity with respect to the difference between a variance and a departure it is important under Jacobs because the departure is tied to the sentencing guidelines calculation, and the variance, of course, is statutory under 3553A. So the mistakes that were made on this record, though, really make no difference because ultimately the court's oral pronouncement that 3553A supported the sentence is consistent with the statement of reasons. If the court has no further questions, I respectfully request the judgment be affirmed.
Thank you, counsel. Ms. Meyers, rebuttal.
First of all, Your Honor, while we're correcting our briefs, I do need to let the court know that my math is completely bizarre in my brief. First of all, we didn't consider the actual criminal history as category 4, so the guideline range would have been 21 to 27 months, not 15 to 21. And then the difference is 13 months, not 23 months. But that being said, a couple of things. First of all, I will say, I do think the government clearly only asked for a departure, but in their defense, I will say that in their motion, what it says is the United States requests an upward departure based on the factors outlined in 3553A. So they keep talking about departure, but they do at least pay lip service to 3553A.
Okay. Well, I'm stand corrected then.
The defendant didn't agree that the guidelines were 30 to 37 months. He said, assuming that that's where the court's starting, because that's what the court was saying, level 15, 30 to 37, that he was suggesting a one-category difference. And I would also note that if we're only talking about criminal history, the probation officer itself, in recommending a criminal history outside the guideline sentence, and probation did ask for departure and variance, noted that—
In paragraph 90.
Pardon?
You said there was a basis for either.
Yes. First they said departure, and then they said you could vary for the same reasons. Even probation noted that had he been in a category 6, the guideline range would have been 41 to 51 months. So I would submit that the 60 months is plucked out of thin air without any explanation of why it should be 60 months. I would note that Johnson, which the government relies on, is a plain error case. In this case, we kept saying, you need to calculate the guidelines, we dispute the guidelines, and—
What if a district judge at the end does say 60 months is where I'm getting based on 3553 factors, he's a particularly dangerous man, and he's always been that? Why wouldn't that almost always— that's going to work under 3553.
I don't think the court can say that without looking at the guidelines, or the guidelines are out the window. I don't think there's any case that says the court says that. The court could say 30 to 37 is even if it's 30 to 37, which is the higher range, I think 60 months is necessary for these reasons. The problem is that both the government and the court, the government, even though they're disavowing the ability to prove the other two cases, they do say preponderance of the evidence, and they talk about how dangerous this guy's conduct in this case was. The actual indictment is based on him having a gun. The danger is based on the challenged facts. Similarly, the court, in saying criminal history, then goes on to talk about concern about this guy's conduct. So it isn't just criminal history. It is all related to this dispute about whether or not Mr. Mcneal was responsible for this other conduct. And that is the concern, that the court must make a determination whether or not he was responsible, and even relevant conduct. For example, in Lopez, which the probation department cites, it's a relevant conduct determination, but it's up to the court to determine, is the defendant responsible, and are these other two acts relevant conduct.
Whether the assistant U.S. attorney was right or wrong, I guess I would have thought that the most compelling case to pretermit a factual dispute would be one when the defendant is facing that uncharged conduct in state court at the same time. I know you're saying that doesn't really benefit him, but I would think that would be where sentencing judges are most advised to pretermit the issue.
They don't, and I don't think it matters, and the problem in this case is they claim not to rely on it, but then both the government and the court talk about it. So if they're really not going to rely on it, then it's got to be pure criminal history. And it may be 18 convictions, but it's mostly staying inside target and stealing something and being caught inside target later. It's not the violent history that was driving the sentence in this case.
Thank you.
Thank you.
The case is submitted. We will call the next case for the day, 23-6.